Thank you everyone for joining us during this session. I hope it's going to be interesting. I'm here with my colleague Vincenzo Giuffré that will cover the different topics together with me. What we're going to cover at the beginning is the overview of the new licensing regime, the new regulations under the new licenses to be issued probably by the end of this year. And then in the second part of this session, we're going to cover the very relevant recent changes to Italian gambling laws, apart from the licensing regime. It's a very busy period for the Italian gambling market that had established regulations for many years, but then last year we had the new sports betting regulations, and this year a new framework of legislation that honestly had never happened before during the last decade. In 2012, we had what is called the community law, and now we have a major change that is going to reshuffle, I believe, also the different market positions within the Italian market. But let's go to the presentation without no further ado. I thought that it would be useful to give you a snapshot of how large the Italian gaming market is in terms of opportunities. It is the largest online gambling market after the UK. It has a GGR of 1.5 billion, and it has been constantly growing. When we had the Italian gambling advertising ban, many operators were really concerned about the impact on the market, the inability of running marketing campaigns, whether that would have been detrimental in terms of market growth. After so many years, to be honest, we need to acknowledge that the ban didn't limit the growth of the market. It is true that many operators introduced what we call alternative communication solutions with some news websites, video websites, and the score results websites that can they are marketed to players. And in general terms, more recently, there's been a higher level of tolerance by the regulator, which has been accompanied by even quite heavy sanctions, for instance, against gambling influencers. So it is a market that it has its own dynamics, but it has a trend that is considerably growing. And this growth has been more and more fast after the pandemic, because during the pandemic, many players that were playing into shops, now they have become online players. And so we had a double-digit growth year on year steadily during at least the last decade. In terms of games, casino games, as in any market, is the most dominant game. Sports betting, also thanks to the major reform of last year, is growing. We're going to tell you about the new sports betting bonus regulations that will also help a further growth. Online casino is growing. I think there is a tendency among operators in diversifying the offering. During the previous years, most of the operators had always the same types of games. So basically, there was a fight between operators in generating the most attractive bonus offerings. Now, the new regime introduces even limitations on the amount of bonuses that can be awarded, and so operators will have to compete on making their offering more attractive to players, apart from bonus promotions. Poker and bingo remain some minor games. There is no provision in the new regime allowing the poker sharing liquidity, that on the contrary has been allowed in a few other European countries. However, the new regime introduces the possibility of arranging agreements between different jurisdictions, and this might open the door to sharing liquidity, because you may remember that the poker liquidity sharing was the result of an agreement among different gambling regulators. All the others implemented it. Italy didn't, but the new law might open the door to this opportunity. The new regime also regulates Lotto. Lotto is a number game that the operators, online operators, can offer as resellers of the exclusive license holder. There will be the tender for the Lotto license, hopefully by the end of this year. It is an opportunity also for pure online operators, because if there is a new license holder, maybe they will do a more attractive Lotto offering. The Lotto tender is definitely an opportunity for large operators, because it is a tender whose awarding cost should be in the range of €1 billion. If we go to the next slide, we're going to discuss now about the new licensing regime, the process of award of new licenses. The tender for new licenses was expected to be issued during this period of time, during these days, during the coming month or so, because the goal is to have the new licenses in place by the end of this year, or at least this is unless there are some delays due to potential disputes or just bureaucracy that unfortunately in Italy it's quite frequent. Next slide, please. So what are we talking about? For those that are not fully familiar with the Italian licensing regime, we don't have a license, a product-specific online license. We have what we normally call an umbrella license that covers all the games that are not subject to exclusive licenses, like Lotto, as I was mentioning before. So basically, with a single license, operators will be able to offer casino games, poker, sports betting, horse betting, betting exchange, bets on virtual events, bingo, and so on. The offering of these games is subject to a technical approval that is per category of game, per game as well, but there won't be a new tender. There would be a tender for this umbrella license. The license lasts for 9 years, and the question that is frequently addressed to us is whether the license is renewable. No, it is not renewable. At the expiry of the term, the operator needs to bid for a new license, with the consequence that if the new license is not awarded, then there is a risk of losing the local business. But a good news is that under the new licensing regime, there is not a bidding process. There is no limit in terms of licenses to be awarded. Whoever is paying the cost of the license is gone and fits all the requirements provided by the law that Vincenzo will cover and are quite extensive and detailed, more than in the past, will get a license. This also means that whoever is not going to bid for a license is going to lose all the business, and that's why we expect some M&A transactions during the coming months, because smaller operators are likely to join forces among them in order to create a bigger operator. But at the same time, smaller operators that don't want to continue their business might be acquired by larger operators. And the dynamic that was in place during the previous tenders is that the previous license is going to be merged to the new license and seamlessly, so that the actual players will not even understand that it was switched from an old license to a new license. The players will continue playing as they used to do, but under a new license, maybe even the number will remain as it is. As I said, there is no limitation in terms of number of licenses, but we will cover it before, after. There is a price that is considerably higher than in the past, and that's why the government expects 45 to 50 licenses to be issued. There is a cap per group, and indeed I've assisted some operators during the last months in M&A transactions across their group, because there is a maximum of 5 licenses per group, because basically the regulator wants to enhance competition within the market and wants to avoid excessive aggregation of licenses in the hands of few operators. Next slide, please. So what is the current timeline, Vincenzo?
Yeah, the current timeline provides that the text has to be considered final, since it's been published in the official gazette, and the goal of the legislator is to have the new license regime in place in the 1st of January 2025. We believe that this timeline is considerably challenging, and we have reported here what are the text of the law, the text of the new licensing regime for the reorganization of the game of chance. According to the new law, the examination of the participation application shall occur within 60 days from the date of the receipt. Otherwise, we are aware that also according to what has happened in the past, 60 days is a very short process, it's a very short period where ADM can review the documents that will be provided from the applicants. According to the test, ADM can request integration, can request clarification, but at the end of the day, if there is not a positive adoption by ADM, the application shall be deemed rejected. We have said that.
Sorry, Vincenzo. One point that normally is one question that is addressed to us is whether at the time of the application the operator needs to have already in place a fully compliant platform with Italian law requirements. No, the answer is no. You don't need to have a platform fully compliant. However, once the license is issued, you have a maximum term of 6 months to launch at least one game. So it is likely that when you apply for the license, you should start working on the platform, because for a newcomer into the market, the Italian law requirements are quite strict and difficult to comply with, because there is an online real-time communication with the regulator, and the requirements are quite unique. So back to you, sorry.
Yeah, what we've imagined is a technical postponement, which window which can be of 6 months. This is because the administrative rules, the technical rules have not been published yet. Since there will be also a time window according to which the participants to the new license standards shall review, can ask questions to ADM that, according to our past experience, is going to respond, there will be a time frame that should occur within the last months. Also, as you can see in the slide, according to the EU regulation 2015-1535, there is a standstill obligation for all those kind of legislative measures that impact the information society services. This law has not been notified to the EU Commission, but it is because presumably the Italian legislator is going to notify the tender instead of the law. But again, this standstill obligation will last for at least 3 months if the European Commission does not raise any other questions. And another level of uncertainty, another feature of uncertainty, is the possible challenging of the tender for the breach of the freedom of services EU principles. We have seen what are the gambling case law at the European Court of Justice, and the most recent one is from 2018. So the European Court of Justice did not evaluate the gambling legislation across Europe during the last 7-8 years, and we are aware that the world has changed in the last 7-8 years, and also the gambling market across Europe has changed. So if a challenge of the new tender will occur to the European Court of Justice, the European Court of Justice will take into consideration the new feature of this Italian tender licensing regime. This is because, differently from the past, there is an open possibility to join the Italian license tender for EU companies. There are no restrictions from a local points of view, even if there are some relative arguments that can be raised with respect to the price of the license and with respect to the length of the license, because, as Giulio said before, the price of the license will be pretty high compared to the past, and the Italian legislator needs to justify the occurrence this new price, presumably according to the preparative acts of the text. It is because the Italian Gambling Authority needs to control the market with a limited number of license holders, but also because they can expect a higher volume of revenues for those license holders who will participate to the tenders. So let's see if there will be like a sort of challenging, especially from smaller operators that cannot. They will challenge the price, we expect. Next.
We have a question that maybe is the question that smaller operators might raise. What happens if the license cannot be renewed? But the fact that the concept of renewal is not a concept that is in the law. If it's more a question if the expiring license cannot be merged to a new license when the term of the license expires. This is a scenario that is possible. However, as I mentioned before, if the company meets all the requirements, it is going to be granted with the license. Now, in the current tender, something that we didn't mention is that all the operators that are currently holding a remote gambling license will have their license expiring at the end of this year. So basically, the old market is gonna apply for a new license, or at least the operators that want to continue operating. Those that don't want, they will just either shut down the business, or, as I mentioned before, they will do some M&A transactions with other operators that want to join the tender, or maybe they can do a joint venture so that they can have transferred their players to the license of another operator and then have bid for the new license with a larger player space. There is the uncertainty that at some point licenses will no longer be awarded, but that never happened since the establishment of the Italian licensing regime, and we don't believe it's gonna ever happen because it's not in the interest of the state to shut down the business. Also, it would it's likely to lead to major disputes. So we don't believe it's gonna happen. It is more likely that at the end of this year, if the new licenses are not awarded, the only operators that applied for a new license or at least committed to apply for a new license will be able to continue operating under the old license that is going to be extended until the new license is awarded. This is something that always happened in the past with the award of previous licenses, whose award was always delayed. So there are these transitional measures that normally are enacted through decrees by the gambling regulator. Next slide, please. So what are the key obligations, Vincenzo?
Yeah, we have summarized here what are the key highlights of this new licensing tender regime. There are new increased obligation for license holders, higher fees. There is a one-time fixed fee of 7 million. Giulio will later discuss about the cost. And then there will be also new provisions for enhancing player protection. So just focusing on I can cover the obligation, the increased obligation. So next slide, please. Looking up which are the key obligations for eligible entities, there are a series of obligations, as you can imagine. We have tried to summarize what are the most relevant ones, but also the differences between the obligation with the past tenders. For example, there is the establishment in one of the European Economic Area. There is a demonstration of experience and integrity in gaming operation with revenues of at least 3 million euros compared to the previous one, which was 1 million and a half. As you may imagine, this is because the price of the license is bigger. Also, the financial criteria is becoming bigger. There should be new technical infrastructure.
On this requirement, the previous tenders provided that if there was a newcomer into the market that didn't have a previous gambling experience, he could still join the process by posting a 1.5 million bank guarantee and a technical report showing the availability of a platform meeting Italian gambling standards. This is not longer provided at least by the decree establishing the regime. We don't know whether the tender rules will open up this opportunity, but based on the current decree and subject to potential additions by ADM through the tender rules, it's not possible for a company that comes from a completely new business to join the tender if they didn't have a previous license either in Italy or in other European Economic Area countries. So basically they will have to either acquire another operator, an existing operator, or they will have to team up with them. But for a new entrant, in the past we had many media companies that enter into the gambling market without any past gambling experience. It's not going to be possible for them to bid for the license under the rules of the decree published in Official Gazette. Go ahead, Vincenzo.
Yeah, I see that there are two questions. One is on the PVR and the skins, but we will talk about this later. And then there is another question which relates to the probity requirements. We can address and answer now. Yes, the probity requirements, according to the text of the law, will be the same, but there are new obligations with respect to the technical and infrastructure requirements. Two new obligations. One is these new policies that should be lodged with ADM that shall certify some cybersecurity requirements. Also, the prospective license holder shall adopt a responsible gaming policy that shall be lodged again with ADM. And as you can see in the next slide, there will be also a requirement to certify the presence of the server that shall be established in the European Economic Area. While before there was the wording, the hardware and the software, while ADM the Italian legislator in this new legislation has clarified that also the server needs to be located within the European Economic Area. There will be, as I said before, additional requirements. A particular attention was raised by ADM with respect to certification and commitments to social responsibility. Mm-hmm. And as you can see in the next slide,
sorry, for those that are not familiar with the existing regime in terms of probity requirements, at the moment, it's necessary to disclose the UBOs that have more than 2% of the license holder of the company applying for the license or be awarded with the license, either directly or indirectly. So basically, you need to disclose the whole line of control until the UBOs, which normally is kind of a headache for listed entities whose shareholding frequently changes. Normally, we don't disclose the UBOs of shares that are traded in the market, but we disclose those that are not traded. It is likely that ADM will be stricter and will require a full disclosure. If there is a change in the UBOs, then you have a 30-day window to disclose the new UBOs. It's just a disclosure letter with the details of the individuals together with the copy of their passports. Nothing similar to what, for instance, happens in the US, where you need to disclose bank statements and so on. But yes, there is this disclosure. And then maybe another factor to be considered is that the technical infrastructure needs the fitness of the technical infrastructure to meet the requirements of the license need to be certified by a third independent party. We assume that it's going to be a testing lab like the one that certifies the grains and platform. And then also, you need to prove the soundness of the company. Go back.
Another change with respect to the obligation is the obtain from ADM the authorization for a license-connected website. According to the text of the law, this website shall be a first-level domain website that shall not be, for example, there should not be no white label solution with respect to other websites. And according to the text of the law, there should be also one app allowed with a logo clearly shown. So what ADM is written within the text.
So on the white labels and skins, the regime is going to considerably change because the regime provides for a single top-level domain name that should be an Italian domain name. So the wording of the of the text is a bit ambiguous because it doesn't say one single, it says one domain name, but everyone has interpreted it that in the sense that it should be one single domain name. And so one of the questions was whether all the skins will be replaced by the PVRs. The PVRs are shops that sell top-up cards to the gaming accounts that will become affiliates of the operator. Yes, this is likely to happen. Also, we have seen some operators whose business is mainly focused on skins and white labels that are engineering solutions in order to ensure that skins are still in place. Obviously, these solutions are not ideal. It's not going to be possible anymore to have a separate website or multiple websites under the same license. It will be a single website that might have multiple web pages with different brands, but the brand of the operator should be on the website, always visible, and that might be something that is a game changer. In one of the questions, they raised that there are operators that have a business with a very large number of skins and a very large number of PWARs. Yes, the business of these operators is going to be impacted. The rationale of this provision is to avoid that there are multiple entities behind the same operator, and it's not possible to see who is the entity actually running the website. So yeah, the technical infrastructure, you say that there is going to be still the need to have it in the European Economic Area. You want to cover the investment plan that is something new, not previously provided, right?
Yeah, what has been said according to the text is that there should be provided this investment plan, but it is subject to the administrative rules that will be published to the tender. As far as we have been aware, there will be also a requirement for license holder to invest 0.2% of the GGR to player protection. And what we have seen in other EU regulation, gambling regulation, is that the Italian gambling authorities in the EU is looking into player protection. So there are several requirements for license holders to respect these measures, and compared to the past, we imagine that there will be a further verification from ADM, which did not occur according to our experience, while the consumer regulation was mostly reviewed from Italian Communication Authority or Italian Advertising Authority, while we believe that there will be an increase also in this area. Yes, I think you, Giulio, have spoken about the only one app allowed.
One question on the only one app allowed. It's like only one website. One of the question is whether operators that have multiple apps per vertical will still be allowed to do that. What do you think, Vincenzo?
I believe that will be just only one app. The text of the law, we have seen a change from the draft of the text and with the new wording of the text, and we see that the Italian legislator have tried to specify that it shall be just one website and one app related to the same license holder. So we believe that there are less arguments than before, where there could be situation just to say that there are, for example, second level domain of website. At the end, we will approve the app, we will approve the website. So we believe that at the end we'll take a look on it.
Yeah, it's more likely that we're going to have one single app that has multiple pages per vertical. But unfortunately, even this requirement might have an operational impact because operators will have to combine all their resources under a single website, under a single app, and so on. I was thinking, for instance, poker that normally has its own app might be heavily impacted because there should be one app that fits all the verticals requirements. Next slide, please. So the cost is the biggest change, if I would say, or at least what everyone is going to talk about in the coming months, because we are shifting from a license whose cost was of 350,000 euros for the same term of 9 years to a cost that is 7 million euros. I was speaking to a client, and apparently this is the highest cost for a license in Europe. It's also true that it is 1.5 GGR billion euro GGR market. So it is a market that generates a high level of return to the operators. Definitely the goal of the legislator is to get rid of small operators that are difficult to control, or at least having these operators teaming up, because as happened in the land-based business, it is likely that they want to have a more limited number of operators that can be better monitored, they are more accountable, you can understand who is behind these operators, and there is more of a higher level of transparency. Even the concession fee is going to be increasing. It's up to it's 3% of the net margin, where the net margin is the GGR net of gaming taxes. I was just reviewing now a new agreement between operator and a supplier of games, and one of the points of attention is whether the commission to be paid to the game provider now will have to consider also the concession fee, because the concession fee before was quite a limited amount. Now it is 3%, and definitely it has a higher impact on the financials of the operator. So rather than just considering the gaming taxes, which by the way don't change according to this law, it is likely that some operators will require their game suppliers to share with them the cost even of the concession fee, but then it needs to be reallocated across the different games according to criteria that are more difficult to calculate than what happens with the normal games. We're going to cover also later on the investment on social responsibility. I see a question on that. We didn't forget it. And also we will cover the regime applicable to PVRs. Next slide, please. So what else changes? Next slide, please. So the PVRs, I was discussing, I mentioned it before, they are points of sale that sell top-up cards to transfer funds to the gaming account of players. So far, they allowed the players to open gaming accounts, and in some cases, also allowed the withdrawal of funds from the gaming account. Okay, so this last point now is expressly prohibited. So withdrawals will no longer be processed through PVRs. The PVRs, the points of sales, will have their own regime. These are tobacco shops. These are shops of any kind that needs to take a license under the local TURPS, the Social Security legislation, but they need to also be enrolled in a national registry that is no longer is not in place at the moment. The enrollment will have a cost of €100 per year. It will require to meet some probity requirements, but the rationale is to make sure that the PBRs are mapped across the territory, and they can the due diligence on them can be done by the regulator. And this €100, it's not a massive cost, but it generates an additional entry for the state. One of the questions was mentioning whether the PBRs will have to change their business. Yes, it's likely that they will become affiliates of the operators, while at the moment larger PBRs have their own schemes. The decree doesn't mention whether you can open a gaming account through PBRs, but we expect it to be possible. The registration will be done online, and it can and you can have the so-called totems within the PBRs that allow players to open a gaming account. The biggest limitation on PBRs, and this is honestly the topic that has been more heavily discussed during the last weeks, is the limit on deposits of €100 weekly through PBRs. So it doesn't apply across all the licensees, but if a player wants to make a deposit in cash or in general terms through a PBR, it has a maximum weekly deposit per operator of €100. The rationale of this provision is that deposits through PBRs that were mainly done in cash could be difficult to trace. Now the law provides that PBRs need to check the identity, the ID of players, and need to make sure that the funds are transferred just to get the gaming account of the player that is buying the top-up card. So it's not going to be possible to buy top-up cards of different operators. This is the limitation. It's really heavy. Obviously, there is a limitation, and operators are working on potential different venues. We've been working for some clients on the creation of e-wallets that could be fueled through deposits that can happen also through shops, because you need to bear in mind that Italian anti-money law provides now a limit of €5,000 for deposits in cash, which is a very large amount compared to €100. So basically, a player could deposit an amount to its own e-wallet, and then from the wallet, the amount can be transferred to the gaming account. In that case, it's no longer going to be a deposit through PBRs, because the code, the protocol code that will be communicated to the servers of the regulator will be deposited through e-wallet. The e-wallet obviously doesn't need to be an e-wallet used just for the gaming activity, because otherwise it's likely that it's going to be challenged. So how the relationship will be framed, it is something to be disputed. The PBRs need to have an agreement with the operator, and there are monitoring obligations on the PBRs, and also the regulation provide a stronger blacklisting process by the tax police in relation to suspicious transactions.
Just to add, Giulio, that the contractual relationship with PVR needs to be notified to ADM, so it's just not a matter of contractual relationship between parties, and because this cannot be a general framework with general provisions, we believe that the ADM will look into that, and the contractual relationship framework should be compliant with the applicable law, compliant with the regulation on the weekly deposit, compliance with the limits, also in terms of responsibility, because as you may imagine, ADM can claim the joint responsibility between PVR and between license holders. And according to the text, there will be a further investigation of the tax police with respect, that I saw before a question of those websites that work like a sort of affiliate.
One of the questions that was just raised is whether there is a B2B licensing regime for game suppliers. No, the Italian licensing regime is only for operators, B2C operators. B2B suppliers are subcontractors of operators, and therefore the operator, they act under the license of the operator. However, over the years, the suppliers have to interface more and more with the regulator for the approval of the games. And normally, the certification process for the games and the platform is contractually on the supplier, even in terms of cost. Next slide, please. So another. Yeah, Vincenzo, another provision, no, maybe it's for me. Another provision that is relevant is the most stringent provision of the most stringent measures for player protection. We already have the self-limitation measures in terms of maximum deposit, exclusions, but now there are additional solutions, even AI related measures in order to identify players that have a potential gambling addiction, and messages that need to be displayed to players in case of conducts that can be risky, and there is an obligation on the operator to ensure that they have a monitoring system in place to identify potentially risky conducts. This is coupled with an investment of 0.2% of the net revenues, so gaming revenues net of gaming taxes, that needs to be turned into responsible gaming campaigns. And as we mentioned here, there might be an impact on the gambling advertising ban. There is a risk that some operators might use the responsible gambling campaigns as actually campaigns to promote their brand. We doubt that it is going to happen, because the campaigns need to be notified to ADM, and if ADM believes that these campaigns are potentially promoting gambling rather than a responsible giving a responsible gambling message, they will reject these campaigns. But it is true that this minimum investment in responsible gaming campaigns that could be used also to the benefit of operators. There is a question: does the regulation also apply to esports? Yes, esports are regulated. They are normally falling under the regime of poker for competitions between players. Actually, regulations of poker or blind poker have specific provisions on soft games like video gaming, and then bets on esports are also regulated and allowed within the market. I would say that there is no major operator in the market at the moment that offers esports competitions. This might be an opportunity for newcomers into the market. At the moment, it hasn't been fully exploited.
Yeah, in this respect, it can be added that the text provides that the license will cover also games in virtual and digital modalities, also with the metaverse, but they will be disciplined by a special circulars that will be issued by ADM. So as far as we understand, ADM is aware of the esports events that sometimes, but in general, games with cash winnings, game of chance with cash winnings that will not fall within the oldest categories. Also because in Italy there was a challenge with respect to some esports LAN operators, and what we can imagine is that ADM is going to issue like a sort of guidelines for deciding which kind of games will fall within the regime of the new tender or not.
Yeah, also to mention that the decree refers to the fact that the regime for the current regime for games will remain in place until the new regulations come into place. There is a bit of ambiguity as to whether the provisions on PVRs are already in place or require the new licenses to be issued. Our interpretation is that, first of all, the registry for PVRs has not been established yet, and so we need to wait for the new provisions to come into place. And secondly, it wouldn't be easy to implement the limitation of the €100 in relation to PVRs that are not mapped. In general terms, the market is reacting in a way that these restrictions on PVRs are not yet into place. Next slide, please.
Yeah, moving on the decree on palpable errors in sporting betting.
Favorite topic, Vincenzo, because we've been dealing with so many disputes during the last years, because there was a famous ADM decree stating that palpable errors were basically a business risk of the operator. Then there were courts that took a different stance on that. But basically, operators were victim of misbehaviors by players that were using spiders to identify palpable errors and taking advantage of them. But this is going to change, right, Vincenzo?
Yeah, what has occurred is that ADM published this circular that will become effective from the 1st of June 2024. And I would say that the most relevant fact is the definition of palpable error. ADM introduced an exact definition of what it is a palpable error, which is a clearly recognizable error where the odds is pretty higher than the average amount. But it is a long definition, but these are the two elements. And this is something that we have tried to argue in courts in the last years. And finally, ADM approved this circular, according to which all the license holder can send by a sort of dedicated application provided by ADM the elements where a quota error will be identified. So it will be requested to identify the date, the malfunctioning, the errors, the odds. There are a series of elements that could be notified to the ADM protocol. The request must be sent within 3 days, and this is a pretty challenging timeline, even if sometimes license holders can identify the palpable errors even instantly, but it does not only occur the case, but it is not only a matter of identification, it's a matter of communication to ADM. But it is very important that if the deadline is missed, it does not mean the operator will have to pay the error, just because the circular expressly says that the matter can be assessed before courts. But as you can imagine, in terms of compliance, the communication to ADM can be also useful before courts, because Italian courts are not really interested in going into deep about gambling regulatory legislation. They prefer to see evidence of fraudulent activities from one side, and on the other side, Italian judges want to see compliance of the Italian license holders. So the fact that the palpable errors will be notified to ADM, we believe, will be also a positive example of compliance and respect of the applicable legislation. What the authority has done is to identify two different methodology to detect palpable errors. There will be a table where the error can be considered like tolerant, so a tolerance threshold for for the odds. It is a really long table, but as you can imagine, there is a tolerance according to which ADM believe that it cannot be considered evident the error. While if the sports betting relates to odds with more than 20 type of odds, there is a multiplier of 4 pair. What we want to highlight here is that ADM, a part of the definition of palpable error and the introduction in the gambling legislation of the palpable errors procedures, ADM introduced the concept of the average amount of odds, which can be a positive element to take into consideration also with respect to court decision, because if it is the same Italian gambling authority that identify which is an average amount, there could be evidence that errors was identified by the players, and the player bet on that event just for the fact that the odds was pretty higher than the average amount.
We're getting a bit over the time allocated to us. There is a question: will all the testing laboratory certification reports have to be reissued once the new licenses come into place? No, normally what happened in the previous tenders is that the new the old certifications will remain valid. They will have to be renewed according to the term that is provided by the law. So as if there was no new licenses, issued. So the old license will be merged with the new license, and basically operationally there's not going to be major disruption apart from the new obligations that we described. One question is on the poker sharing liquidity. I mentioned it before. Yeah, there is a reference in the law to the possibility to regulate games also by means of bilateral and multilateral treaties. This seems to infer that the agreement reached by ADM together with the regulators of France, Spain, and Portugal in 2017 might be the legal basis of this sharing liquidity. It needs to be considered that an ad hoc piece of legislation still will need to be in place, because from a technical standpoint, we will have tables with players that act under different regimes, and for which the protocols of communication need to operate differently. For instance, Italy has the concept of gaming session and funds transferred to the gaming session within the limits provided by the law, which is not a concept in place in other jurisdictions. So I believe, yes, it is would be possible. It wouldn't require a primary law. It's likely that it would require an agreement with two regulators that is already in place together with the NADM decree. My feeling is that maybe the market is now more mature and it could allow that. In the past, the concern was more relating to potential money laundering conducts, but now there is a consistency across Europe on money laundering legislation that should no longer justify this sort of country-specific discrimination. It is true that Italy has more gambling-specific money laundering provisions, but these are also provided in the legislation of other countries. Actually, a few years ago, we ran a review of AML legislation across the 4 countries that reached the agreement, and the result was that there was already in place a high level of consistency. What other question with regards to the traceability of flow? Do we know whether IDM expects operators to investigate on the source of funds? Well, this is already provided by the legislation. AML legislation requires to investigate on the source of funds. If you refer to the flow of funds across the different entities involved, basically maybe the problem is whether the money is transferred in cash from an e-wallet and then from the wallet to the gaming account, which is the solution I mentioned before. It should be considered that the company managing an e-wallet will still have a banking license. It will be either a payment institution or any money provider. So it will have to act under its own regime, with its own AML checks, and so it's not going to be a free regime that without any sort of check. Last slide. Yes, we are going to record the webinar and making it available.
I can go through the last slides very quickly. 3 types of bonuses allowed according to the new circulars. Bonuses for cash winning redemption is the same, and also bonus payout. DM introduced the reduced payout bonus, meaning that if you bet €50 with cash stake and €50 with bonuses, obtaining a winnings of €200, you can reduce the bonus, the €50 bonus. According to the law, the amount of bonuses cannot be higher than the stake. And what we have seen, the major regulatory changes is the limitation on the amount of bonuses that can be offered by a license holders, because it has been calculated that it is the 50% of the difference between the GGR and the amount paid in winnings. As far as we have been aware, IDM has recently issued a circular within the IDM reserved area of the license holder, according to which IDM will communicate the amount of bonuses that can be offered in that month, considering the figures of the previous months. And we believe that it will be like a sort of a self, when you offer more than the amount that has been highlighted by IDM, the license holder will receive like a sort of error message. And then there will be also some limitation with respect the amount of bonuses that can be used by a player. So it's 100 euro per, no more than 100 euro. No possibility of cash out when it is using bonuses. But in any case, the decree on bonuses is pretty clear, and these sort of changes and limitation are addressed within this new circular that will take effect on the 1st of June 2024.
Yeah, it's gonna be a game changer. It's definitely gonna to impact more heavily newcomers into the market, which obviously have a lower GGR, but that's why we expect some M&A transactions by operators that want to take a market position that might acquire smaller operators in order to have their big launch GGR that is already quite decent. Last slide. Yeah, this is us. If you have questions, last comment. Where this is not just a one-off webinar. We're gonna have periodically some gambling related webinars. Next one should be on the gambling related litigations between operators and players in Austria and Germany that are big major disputes. So just follow us and required to be included in our mailing list, and we will update you on the coming webinars. Thank you, everyone.